Coming up on Trust and Trade.
When a firm with power conditions access to something you need on taking something you don't, that's inherently suspect, right?
Hello, and welcome to Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. On this show, we help you understand the legal and policy issues shaping competition, consumer protection, and privacy, whether you're deep in the field or just trying to make sense of the headlines. Each episode is brought to you by one of the section's specialty committees. Today's episode is produced for the Distribution and Franchising Committee of the Antitrust Law section. And today, we're heading into the intersection of antitrust law and heavy metal, the case of Ozzy Osbourne versus AEG. In April of this year, state attorneys general won a major victory in a monopolization case in which a jury found that Live Nation Ticketmaster illegally maintained a monopoly in the large amphitheaters and concert venue ticketing markets. The jury also found that Live Nation unlawfully tied artists' ability to perform at large amphitheaters to the use of its promotional services. But when you talk about tying claims in rock and roll, no figure looms larger in antitrust than the Prince of Darkness. I'm talking, of course, about Rock and Roll Hall of Famer, Black Sabbath frontman, and endearing reality television patriarch, the late Ozzy Osbourne. Because the seminal heavy metal antitrust case was 2018's Ozzy Osbourne versus the entertainment company AEG. In his case, the Wizard of Oz, two Z's, challenged AEG's practice of block booking. And ultimately, his case, like Ticketmaster, was about tying whether a venue monopolist in one geographic market, in this case London, can force customers to use a venue in another market, in this case LA. What happened in this case reverberates today in how we think about proving a tying case, even in non-headbanking markets. So joining me today to talk about the significance of this case, Gwendolyn Lindsay Cooley, the founder of Taimet, an AI-powered merger analysis software tool. She served for 20 years as Wisconsin's Assistant Attorney General for Antitrust and led state attorneys general nationwide in their antitrust efforts in the first half of this decade. Also returning to the show is Travis Wheeler. Travis is a shareholder in Maynard Nexsen and has been repeatedly recognized by his peers as a legal elite for the Midlands. He is also an adjunct professor of antitrust law and trade regulation and law and economics at the University of South Carolina School of Law. Welcome, Gwendolyn, and welcome back, Travis.
Oh, thank you.
Thanks for having me.
Travis, why don't you kick us off and tell us a little bit about this amazing case that only happened less than a decade ago?
Well, when Ozzy Osbourne passed last year, R.I.P. Ozzy, he left an enduring legacy, but we can't talk about that legacy without talking about antitrust. I didn't know that's jumping the shark, but I could not help myself. Yeah, in 2008, this was kind of kicked off when, through his promoter, Live Nation UK, he attempted to book the London O2 Arena as part of his final tour, or third final tour. And when he attempted to do so, he was confronted by the Staples commitment. So I will let Gwendolyn talk about what exactly the Staples commitment was.
Yeah, so the Staples commitment is, in my opinion, the quintessence of a market power exercise renamed and rebranded as something benign. It literally branded a tying arrangement and required any artist playing in the O2 Arena in London, if also playing an indoor arena within 25 miles of LA, they have to play at least once in the Staples Center.
And so why, for Ozzy, was this an issue?
So in London, Ozzy really only had one choice, the O2 Arena. This isn't true in LA, which has many options. And I'm told, and I learned from reading some of these cases, not from actual experience, that apparently there's nothing quite like an outdoor arena concert. To me, it sounds like my worst nightmare, but there you are.
Ozzy, through his lawyer, alleged a per se and a rule of reason tying claim. And I was hoping you could talk a little bit about how he differentiated those two tying claims in his allegations.
So it goes very much to the law. So avid Antitrust 101 listeners will know from the recent Jefferson Parish episode, where we reference this podcast, that per se tying can only be successfully used against blatant monopolies. So that's the differentiation that Ozzy needs to make. He's saying that here there's a blatant monopoly, because mostly courts look at tying cases as rule of reason. So if Ozzy was able to demonstrate that the tie the combination of the two products, had anti-competitive effect, he should be able to prevail under either standard. So as a general matter, the burden of a rule of reason case, we all know, means that plaintiffs don't bring a case. But if they're up for the challenge, this is a brilliant way to plead it in the alternative, alleging either or.
Hedging the bets.
Right, exactly.
So AEG filed a motion to dismiss, may have been a little bit on the ridiculous side, in that they attempted to rely on a Fourth Circuit case that happened to have been brought against Live Nation. How did that work out for AEG?
Well, in short, Ozzy won.
Yeah.
So worked out well. So first, the defendants here attempted to rely on, and I am super not making up this case name, and as a person who has now named two companies, I have a lot of sympathy. I've explained how to say Taimet about 10 times in my life in the last week. There is a case called It's My Party, is the name of the company, versus Live Nation. In that case, plaintiff IMP, It's My Party, and defendant Live Nation both operated outdoor amphitheaters. IMP claimed Live Nation was using its power in the contract promotion market to force artists to use its own particular amphitheater in the local Baltimore-Washington market. In IMP, on a motion for summary judgment, the district court found that there was no forcing and ruled that this was bundling promotion services with a venue, and the Fourth Circuit agreed. You know, is this fact patterns a little familiar to anyone? And I think, as Anant referenced earlier, maybe my friends in the States who just had better facts on this exact question, according to Judge Supermanian. For Ozzy's purposes, though, there's case law back to the 1950s about the importance of defining separate products when examining a tie. So what is a separate product? Right? Products that are not absolutely required to be sold together, but they are. So, for example, a tennis ball, where it's 3 to a can, is unlike a pair of shoes, left and right, which are functionally not multiple products. So lines can, of course, be blurred. You know, it's springtime, so if you go and buy a container with soil and plants in it, all three of those things can be purchased separately, but sometimes it's just really nice to have it all ready to go in a bundle. So that's why courts typically often think bundling is okay, but tying is not okay. Of course, there's squidge in that, and that's where you'll often see defendants in tying cases argue that they're bundling, not tying, like Live Nation did in their trial against the states. And this is part of how antitrust lawyers earn a living, right? It's litigating the squidge. But the court in Ozzy's case was having none of this. It found that there are clearly two separate markets, and this court held that in a blissfully short motion to dismiss ruling. Wisely, defendants settled shortly thereafter, and Ozzy was able to claim victory.
Well, the word of the day is definitely squidge. But Ozzy had both rules at his disposal. He used both of them. But why do we have two rules in the first place?
There's a practical answer and the legal answer. And let's be good nerds and, of course, start with the legal answer. And that's Jefferson Parish, this 1984 case that reaffirmed the bifurcated quasi per se and the rule of reason approach. So quasi per se, you have an anesthesiologist who sued a New Orleans hospital after being denied privileges to practice there. There's 3 or 4 elements, depending on who you ask. I think that there's 4, because first of all, you have to have 2 products, and then you have to have market power in the tying product, right? The product you want, and then the conditioned sale, that's also called the forcing part of tying and forcing, and then a substantial volume of sales in the tied product. That's the market that's affected.
And in Jefferson Parish, did the court find a per se violation?
They did not find a per se violation.
Okay. And arguably, if when a per se violation fails, a plaintiff can have a second bite at the apple, arguably, if they fail under per se. But what else do you need to show, once you have failed in your per se claim, to prevail under a rule of reason?
Yeah, I wouldn't call it a second bite at the apple, because proving rule of reason is, frankly, a heck of a burden. So what plaintiffs show and what Justice O'Connor in Jefferson Parish, bless her, just outright says is these cases should be rule of reason because no one is saving any time, pleading per se, because we're all doing an elaborate dance with these cases anyway. So plaintiffs must also prove under rule of reason substantial foreclosure from a relevant market. It was the market of anesthesiologists at this hospital.
So that was the substantial foreclosure, I guess, that Hyde was alleging was the market for anesthesiologists in one smallish hospital in East Jefferson Parish. Is it possible to substantially foreclose market power in the tied product without enough market power in the tying product to trigger per se liability in the first place? How does O'Connor's concurrence in Jefferson Parish, feed into this question?
This is the elaborate dance that she talks about, right? She says without saying, look, with the rule of reason, because it's such a pain to prove, at least you'll only have the really egregious cases anyway, the ones that are practically per se illegal. So the majority plurality decision is really just making things more complicated with its what level of monopoly is it? Is it a railroads own the entire West level monopoly, or is it a Live Nation jury verdict level monopoly? So what smart plaintiffs end up doing is pleading both, which, that's time wasting, but courts also see the dance when you do that, right? And so they end up finding things to be both unreasonable and per se. And I've seen that in not just tying cases.
So she did not seem to have a lot of heartburn over jettisoning, per se tying and thinking, Dr. Miles, there have been other areas and aspects where that heartburn does seem to kind of take hold of justices. Why not here for Justice O'Connor, you think?
Well, I have to say, Dr. Miles, they didn't seem to have much heartburn in overturning that either. But it's clear from Justice O'Connor's concurrence that she thinks the focus should be on the real-world economic impact of a tie, and she nods to the good old antitrust paradox for that, right? She seems to think that some tying is bad enough to merit per se treatment, particularly when there are other antitrust shenanigans like price discrimination or there's regulated industries at stake. Personally, I dislike that for her, because if your point is that it's overly elaborate and time wasting, then just say it's all rule of reason and just have a bunch of expensive economists jump in the hot tub and start talking.
What did her rule of reason look like? Was it a little bit unique to tying?
Yes, she has a 3-step analysis, but I have done what courts are doing nowadays, and I've cleaned it up for her. I've made it into 4 steps, and I've rearranged them. So 0.5, or I got in my step 1, 2 products, right? And then I've moved her step 3 to step 2, coherent basis for treating those 2 products separately. And then, if you got all that, then you get to, is there market power in the tying product, and then a substantial threat of achieving market power in the tied product. And so if yes to all 3, then proceed to the second step. I guess this would be step 5, a traditional rule of reason analysis. So step 1 operates essentially like a quick look to exculpate, like NCAA versus Alston. That's everyone's favorite case, moving even the NCAA toward rule of reason territory. Although I have to say I'm kind of partial to Kavanaugh's concurrence there, but that's another episode.
So I think it's safe to say that her dream has not yet been fully recognized. But is it fair to say that we have moved closer to kind of a single rule of reason Section 1 standard for tying in the 40 plus years since her concurrence in Jefferson Parish?
Well, I think we've certainly retained a lot more economists in the last 40 years. So even if not fully realized, we've certainly moved very close to her ideal. And we can thank Justice O'Connor, amongst others, for that, right? You have the original tying cases like international salt, though recognizing something pretty basic. When a firm with power conditions access to something you need on taking something you don't, that's inherently suspect, right? later cases like Microsoft, that famous tying case, didn't reject that intuition. It just layers on another level of analysis that in practice can turn straightforward tying, in my opinion, to a battle of economists. Because the reality is firms with durable power don't just announce their foreclosing competition, they design around it. And I think that's especially true nowadays, right? They use contracts or defaults that achieve the same result. If the legal framework requires plaintiffs to disentangle all that through some fulsome rule of reason inquiry every time, you start to underdeter the conduct that matters most. So for me, when I hear this is just bundling, I go back to basics and think, okay, do consumers have a meaningful choice? Is access to that must-have product being conditioned? Are rivals being cut off from distribution or scale, right? That's Microsoft. So if the answer to those questions is yes, it's my belief that we shouldn't need a small army of economists to say something is wrong. There are other people who very much disagree with me on that. So the law has long recognized, though, that coercive tying by a truly dominant firm is a predictable way to extend power. And so I think we shouldn't make that harder to prove than it needs to be. That said, even in rule of reason land, remember what Microsoft says. Foreclosing rivals from cost-efficient means of production is still an antitrust violation. So I wouldn't hang your hat on having all the plaintiffs plead rule of reason. Anyway.
Maybe stepping into a minefield with this one, but what happened after the DC Circuit remanded Microsoft for the DOJ to pursue under a rule of reason?
So here's what I know you want me to say, which is that the DOJ declined to pursue a rule of reason tying claim. However, it's so much more complicated than that, right? And I think that's always the case. We have to think about things in the real world, because by the time this case gets remanded and gets a new judge because of some of the other stuff in the Microsoft case, there is a real conversation between the new presidential administration of a different party than had brought the case and the states who were co-plaintiffs, which everyone forgets. And then the parties end up in mediation for, according to my sources, about 5 weeks, like from the end of September. And then the settlement is filed on November 1st. So, they declined to pursue the rule of reason tie, but asterisk.
Okay. Well, you got me because you knew exactly what I wanted you to say, because I also wanted to ask you in the aftermath if that suggests in any way that the DOJ viewed the rule of reason claim as futile after it lost the per se. And I think you've sort of already previewed your answer to that, but I'm going to ask it anyway.
Look, the DOJ is saying we don't want to prove a rule of reason claim, right? And it is a perfectly reasonable stance to say, rule of reason, too complicated, too expensive, we're not going to bring it. I think my friends would disagree in the States because you can still bring them and win, especially after their recent success suing Live Nation.
Yep. So, I guess we do have, still two rules. We have the, quasi per se, and we still have, a rule of reason. But is it fair to say that support for per se tying, the idea of that, is continuing to dwindle, considering you've got post-Microsoft technological ties are exclusively rule of reason? The DOJ's antitrust division has advocated for all ties to be rule of reason. And if you look at the ABA law developments, that seems to suggest in the ninth edition, at least, that the content of rule of reason is not well defined. And that if a plaintiff can't show sufficient market power to prevail under per se, it is not clear how that plaintiff is going to be able to show, the necessary foreclosure under a rule of reason either.
Right.
So now that I've poked the bear, I'm going to sort of let you respond to that.
Well, I like picturing myself as a bear. So, it's my job to prove what courts want me to prove, right? And I like to say that they don't care what I think. Courts, in my opinion, like the seeming objectivity of math, and they like the freedom to do justice. Courts love economic evidence because it makes our squidginess word of the day of doing justice every day a little bit less squidgy. But moving away from per se rules allows courts flexibility, right? Oh, surely this is a good tie. Allows courts to do something that they just love doing, right? Justice always with a soupçon of math to support that. My humble opinion, the current US DOJ and ABA law developments with great affection and respect largely hold a traditional, non-interventionist, pro-defense conservative viewpoint. And I think that's because of rule of reason and that view that tying cases are unwinnable. And that's fair. I appreciate that instinct, even if, in my opinion, it's wrong, because a robust democracy needs a robust defense bar. But they're not MAGA antitrust. They're not Lena Khan. And one can still win these cases. Just like Ozzy did, you're going to have to hire an economist anyway. So what the heck? You can plead a rule of reason case, just like the states did.
My new favorite phrase is the seeming objectivity of math. I'm going to use that one.
So focusing on just the Jefferson Parish majority opinion, when I tell my class when I hear people talk about their understanding of the majority's split between rule of reason and per se tying, it sounds to me like when people tell me how much they enjoyed reading Finnegan's Wake, and I am skeptical. But there is one, diehard defender of Jefferson Parish in Harvard professor Einar Elhage. His take on Jefferson Parish, I think, is that it's sort of a brilliant, if misunderstood, decision, but certainly defends that bifurcated rule. And for him, if there is overwhelming market power in the tying product, then there's no need to prove injury to competition. That's his kind of quasi per se. And then if not, then you kind of look over to the tied market in terms of dollars, not share, but is there substantial foreclosure in terms of sales in the tied product? So what is your kind of take on that understanding of the hair splitting in Jefferson Parish?
So I understand the instinct for the quick look and Jefferson Parish type of case, but there's a reason the Congress created this as a per se rule in the first place. And I'll note that there is an oft mentioned additional concurrence in Jefferson Parish that is basically like, look, the dude loses under per se, why don't we just be done with it there, right? There's a reason Congress created that per se rule, and it's clear that plaintiffs, defendants, and our court system are not well served by engaging in 10-year-long litigation every time they bring an antitrust case. So that's just my take on that. So with respect to the esteemed professor from Harvard.
Do you think going forward, that Justice O'Connor's view will eventually prevail and it will kind of convert all tying to this rule of reason? And if so, do we need to sort of define a difference between market power and overwhelming market power? Market power like pregnancy, you either have it or you don't, or are there levels of it?
Right. So I think tying itself is more like the legal definition of pregnancy. So it's capable of repetition except evading review. What is the end? Right. I think we're going to move back and forth. I don't think courts will ever put a number on market power because, again, right, it's that math and justice combo. A jerk at 29.5% is going to be found to have market power, and a natural monopoly at 31.5 is not, because courts love numbers and they love justice. It's more like, in my opinion, the legal definition of pornography, which we know it when we see it.
So let me, if I can, just give you a fairly unrealistic hypothetical, but you've got the sort of proverbial gas station in a desert intersection, dozens of miles from anything except for a water stand across the street. If a car drives through, gets gas, and and the sale of gas is tied to, conditioned on also purchasing a bottle of water. Does that gas station and those facts, does that have the overwhelming market power that some have, used as a trigger for finding the quasi per se?
Yeah, I mean, I think absolutely, right? Because you've got a gas station in the middle of the desert. It's one or done, right? Like if you're on a gas, you have no choices. And I mean, unless there's another gas station in close proximity, there's pretty good merger cases that define a market for gas stations. It could even be the same side of the street. So there's that. Also, to heck with you. If you're going to make me buy a bottle of water, what if I wanted to buy a Sprite? I mean, right? What if I wanted to buy nothing? What if I brought water with me because I was driving through the desert, right? Like that's exactly the kind of tying and forcing that Congress was really trying to prevent, I think.
I mean, that does raise an interesting point. I think kind of from the frame of reference of the buyer. If that buyer comes through and does not want to buy, anything to drink, the buyer is not thirsty, does that change the analysis?
Yeah, I think it really does, right? Because that is, you're being forced to buy a product that you don't want. You're essentially paying a premium because you are forced to buy water that you wouldn't otherwise have. I think that's where you would definitely get into that per se rule.
But from the perspective of the water stand, is that water stand losing? It's not losing a sale if that buyer wasn't going to buy water anyway. If the buyer is being forced to buy, the water that the buyer does not want, is that a different case than if the buyer did want water but would have preferred to buy it at the water stand across the street?
Right. So antitrust protects competition and not competitors. Right. You'd still have to look at the consumer harm, I think, there.
Yep.
I mean, living in the world that we actually live in, I think you do have to look at the consumer harm. If I don't want to buy water, then I am being harmed.
Yep.
And I would think that's your best class of plaintiffs in that case.
Yep. So they're, kind of per se, that would trigger, we think, a time violation.
For sure. Yeah.
What about under the O'Connor approach? If we are still talking about just that first, the first sale.
Yeah. So I think she might think that there's not a danger of achieving the monopoly in the bottled water market with the one sale. However, right, one of the things that the court is really, and we didn't talk about this earlier, but in Jefferson Parish, the court is really affected by the fact, it's a classic bad facts make, in my opinion, bad law, because you've got one dude who can't get into an anesthesiology practice, right? So the impact on commerce is low. The anti-competitive effect is low. If I am the only person who ever goes through that gas station, I would say Justice O'Connor would be like, Ms. Cooley, you're out of this court, right? No danger of achieving a monopoly, and the impact on competition is tiny.
And if we were to apply the the El Hague rule of reason, how does that fare under that standard?
Right. I think he has a very similar standard, right?
Yeah.
So I would think he would find it to be the same, not condemned.
Yeah. Okay. So it's kind of a, and then you've got a situation where under a rule of reason, arguably not condemned, under per se, it is condemned. Is there any, and I think I may be walking another minefield, but, is this an example, sort of a false positive, where we need to be concerned about, over enforcement?
So let's be clear on whether that case would ever be brought in the first place, because, you're only, I think, if this case were presented to me as an enforcer, I'd give it a go, because at the very least, you're going to get a court to issue a restraining order against them forcing you to buy something at this one station. I don't think it's an over-enforcement situation, because in the reality, you're talking about a gas station. Yeah, right. Like, so the likelihood of it actually being enforced is low. That said, if this meets per se, but doesn't meet rule of reason, it doesn't meet Justice O'Connor's rule of reason. I think that there are ways that it could still meet rule of reason. So I'm not willing to concede that yet.
Okay. I'm going to make this even more unrealistic. Same facts, but now there is a second gas station. That does not have any kind of convenience store. So you've got one gas station that has a fridge and sells water and drinks, and one that doesn't, and you've got the same water stand across the street. In that case, do you still have the ability to force water sales to the point that they're problematic?
I think you would need to look at the consumer harm, right? So let's assume, for the sakes of this hypothetical, to make this really even, that the gas prices are the same. And if the gas prices were the same and there would be no consumer harm from the forcing, then you could certainly go to the other gas station, right? Because then potentially the market power would be the same. Because, right, you have to look at that market power question in order to have that, right? And you assume, okay, let's assume they're right next to each other on the same side of the street even. So they've got 50% market share each. One forces you to buy water, the other doesn't. I think, again, water stand is competition, not competitors. So yep. I think the question is, what is happening for the consumer? And one is saying you don't have to buy water here. I would put that on my sign. No water required. I mean, I think unlikely, first of all, that case is never going to get brought. I mean, regardless of whether it meets a rule of reason. And that's part of that, what do the courts think? Why won't they put a magic number on it, right? Because is it super inconvenient to go to that gas station? You can change the facts, right? You could make the gas station, it's a mile in the other direction, and you got to go way out into the desert, and you're like, are we going to die out there? Are we going to run out of gas before we get there in order to go to the station that doesn't have water, right? So I think you need additional facts here, but I think that one's a harder case.
So trying to come back to actual cases that could happen, I think neither one of those could. Ozzy, the Ozzy case, I think for you, from your opening remarks, you find that to be a pretty easy case of, per se, why we have a per se rule. But, even under O'Connor's or the O'Connor Cooley 4-step, still fails.
Right.
Okay. And, Jefferson Parish, I think we've kind of talked about that, too. It's kind of a quirky case with one sort of disgruntled anesthesiologist who really likes that hospital. What about Microsoft? I mean, it's a little trickier, but how does that? I mean, because it is kind of the next big time case after Jefferson Parish. What happens if we apply a per se rule to Microsoft?
I mean, they did appear to have overwhelming market power in the browser market, right? And so tying Netscape, right? That was the allegations.
And because they were not allowed to proceed under a per se rule, DOJ elected to continue under a rule of reason. Fair to say you do not think that would have been, a futile effort?
I don't think it would have been futile for DOJ to continue. I mean, right. Obviously, I think what they did worked out well, right? Because they settled the case, but Microsoft, I mean, again, living in the real world, there is an argument that even just the fact that litigation was brought helped allow the platform that I'm certainly using right this second to, come and be a competitor to the Microsoft browser. But Netscape went bye-bye. So, I mean, was there a dangerous probability of monopolizing the browser market? We'll never know for sure. But certainly there was harm to competitor regardless of whether they would have been able to prove harm to competition.
What I'm hearing over the last even 30 minutes or so, in some ways, is kind of a refreshing, like kind of return to the consumer welfare standpoint of time that seems like it's gotten a little bit lost in the last 67 years. We get so worried about, whether or not a competitor is foreclosed or competition is foreclosed. But those early cases, I think the SALT cases were more on, am I being forced to buy something I don't want?
So this has been a fun way to frame an issue that has a lot of resonance today and is something that I continue to grapple with, which is how do you analyze a tying case? And for our listeners, we are planning a future episode on the Live Nation Ticketmaster case where we're going to have some of the litigators from the states talk about the case. So if you have been enjoying what you've been hearing today, stay tuned, and we have a future episode dedicated to that case in particular. But Travis, Gwendolyn, we like to close these episodes with a few key takeaways for practitioners. So Travis, let me start with you. What do you think are the key takeaways here?
I think the key takeaways are, there are still two rules. I think there is, less consensus on the need for two rules, but I think it's still very much an open question. And I think that, even if rule of reason and or Section 2 is sufficient to address anti-competitive ties, I think, what we've heard today is, maybe the point is we shouldn't have to employ the rule of reason for all ties, and that there really are some, and I think Ozzy is a pretty good example, where you don't really need a full rule of reason to analyze the effects of a tie. And it's looking at the O2 arena and the Ozzy one. It's hard to understand any effects other than benefiting the tire. So that's my takeaways. Gwendolyn, do you have any other ones?
Yeah, I would say you can plead rule of reason and still win, as Ozzy demonstrated. I'm not metal enough to do the hand gesture. Sorry, not. And I would say good facts make good law. Sympathetic plaintiffs make, for winning cases. And also making sure that you have in your pocket the ability to plead financial harm to consumers. That really, right? Ozzy would have been able to prove that. So that'll really help. All right. Well, Gwendolyn Lindsay Cooley and Travis Wheeler, thank you for agreeing to be on this very special heavy metal episode of Trust and Trade. To our listeners, be sure to subscribe on your podcast platform of choice and follow us on YouTube. And we'll see you next time. Trust and Trade.